Hang on 1 second, because you're not on my docket today, so hang on.
Call my name, sir.
What's that?
You just called my name, Your Honor.
I did, because it's written on the Zoom name. It's not on my docket sheet, though. Case number 22020259.
Yes, sir.
Wayne County Land Bank. Versus all occupants, okay. So you live on Ziegler Street?
Yes, Your Honor.
All righty, so. Today's the date and time set for a pre-trial. Attorney Brooks.
Your Honor, am I able to make any statements regarding any matters in this case?
First off, put yourself on the video, because this is a video conference. I'm not going to talk to your hair.
Oh, I apologize. This is going so slow. I said, am I able to make any statements regarding any matters in this case?
Are you going to be able to make statements?
I mean, in today's hearing right now, can I make some statements?
Today's just a pre-trial. Today is just an opportunity for you to meet with the other side, discuss the matter, and then next week is the hearing. So there's really no statements being made today. Today is just a pre-trial. So I'm going to put you and Ms. Brooks. I'm going to put you and Ms. Brooks into breakout room 2.
Okay, thank you.
Ms. Brooks, you had the opportunity to speak with Mr. Pearson.
I did, Your Honor.
Mr. Pearson, with the phone, are you recording this right now?
No, I'm trying to make sure you can see my face. Can you see me?
Yes, I can see you. I can see you.
Okay. Okay. Yes.
So what is your name for the record? Just so I make sure I have it correct.
Okay, my name is Emmanuel Quentin Wiley Pearson L.
Okay, so hang on, Emmanuel. So I'm gonna write this down. Emmanuel Pearson Wiley.
No, middle name is Quentin. Last name is gonna be Wiley Pearson L.
Oh, okay. Hyphenated or no on the Wiley Pearson?
No hyphenated.
All right. And I'm gonna have to ask you if you could, the middle name, could you spell that for me?
Yes, Quentin.
Okay. And then L, is there a comma after the Pearson and then an L, or a hyphen and an L, or just L?
No, sir, just L, E-L.
Okay, sure. All righty, and you are currently residing at Ziegler and Taylor?
Yes, but I have additional properties. I might not be there every night, but that is one of my houses. The gas is on, electricity is on in my name.
Okay.
My neighbors harass me.
This is a termination of tenancy. So the alleged rightful owner is asking that you vacate the premises, and we're set to have a hearing on March the 1st at 1:15. Did you guys work anything out, or we're just going to come to hearing on March 1st?
They no longer have a lien. I removed their lien in the district court. I have a federal open case number. She tried to read me a case number that was already closed. Then she had an action that pertained nothing to the defendant that it was listed was with an old defendant in which we made errors. There was no errors.
So, hold on, Mr. Do you prefer Mr. Pearson, Mr. L? I just want to.
Yeah, it doesn't. Yes, it doesn't matter.
Okay, so Mr. Pearson, today's not the hearing. Nobody's under oath. Today's just a pre-trial. I'm just saying. So, Ms. Brooks, are you prepared to go to a hearing on the 1st?
Yes, Your Honor.
Do the parties need any time to file any motions or briefs for motions?
Yes, absolutely.
So,
even though I'm filing a notice of, Your Honor.
Yeah.
I'm filing a notice of claim, removal from state court in the district court that it's already in, a foreign arbitral award.
First off, hang on. First off, I have original jurisdiction over any of the landlord tenant type stuff. Second, I have not received an order from any federal court vacating my authority and removing this to the federal level. So until
Yeah,
I
because
do, I still have jurisdiction. So,
no, I understand. That was because you have never received anything. You've
okay,
never received
so-
anything.
Sure. So we have it set for March 1st. I'll see everybody on March 1st, 1:15.
Thank you, Your Honor.
Thank you, Your Honor.
And then, do we need to do this, I'm assuming that there's gonna be documentation.
Yes,
Okay, then let's do this in person
please.
here at the courthouse.
Oh,
Okay.
wait, I'm out of town.
Well, it's March 1st, so I'm having it here March 1st. So that's when we're having the hearing.
How do I put it?
It's too hard to do it by Zoom when there's a bunch of documents to look at. So if people have documents to look at, I want to make sure everybody can see them. I want to be able to see them. So we're going to set this, it's already set for March 1st. I'm just saying that it's going to be in person here at the courthouse. So I'll see everybody here at 1:15 on March 1st.
I can do it in chambers
Your
of
Honor.
special appearance. I can do it in chambers by special appearance.
Say again?
I can do it in chambers by special appearance.
Okay, you're going to show up here at the court on March 1st. All right.
Yes, through the mail.
All right, I'll see you here on March 1st in person, everybody.
Thank
All right,
you.
thank you.
Everybody out there in YouTube land and everybody here at the 23rd watching. Have the rest of your day. God bless America.
Numbers 31 and 32, People versus Taft Lewis, 16432 FH.
Well, this was adjourned from last week. So here we are.
Here we are. You have the opportunity to speak to Mr. Lewis.
Not really directly to Mr. Lewis. We did mention to Mr. Judge Conlon that I was thinking, based on the fact that he's been struggling financially, if the court would be willing to waive the waivable fees, that would leave him a $73 mandatory balance. We never really got that far. So,
Okay. All right. I see there's a range on the bench warrant. He'll owe 73.
yes, that's correct.
What's the amount of the waivable?
He owes $2,045.80. Of that total, $73 is mandatory.
Okay.
And he's paid $125 so far.
Mr. Attorney General, what do you have to say?
Well, I guess I'm not entirely clear on the basis of the violation. I don't have, I'm not sure I've received documents regarding that. With respect to the underlying child support case, Mr. Lewis currently owes $21,415.70. And he has a current obligation of $66 a month. That's 66. And his last payment was in August of 2022. Further, I also am not sure if Mr. Lewis has any representation in this matter or not.
No, I'll be representing myself.
Oh, okay.
I have PD written down here, but
I did try and see him this morning, Your Honor, but he said he's representing himself.
Yes, ma'am.
oh, okay. So I'm sorry. I thought Mr. Gaddy was here on this. Sorry.
Two issues,
Okay.
the collections issue and then the probation violation.
Okay. So as to the collection issue, I can waive the waivable amounts. And Mr. Petherbridge, if you submit an order for that, leave
Will do, Your Honor.
balance at 73, you said?
Yes, that's correct.
Okay. And Mr. Lewis.
Can I speak now, Your Honor?
Yep, just a minute.
No problem.
Okay. Mr. Lewis, pursuant to Court Rule 6005, you have the right to the assistance of an attorney. So I can read you this section here if you're interested in
No, ma'am.
representing yourself.
Yes, I am, ma'am.
You are interested in representing yourself.
Yes, I've been
Okay, hold
representing
on.
myself since 2010, ma'am.
Okay, well, so then you've probably heard this a time or two, but we're supposed to read it to you every single time you come to court.
No problem.
Okay. So hold on just 1 second. Says here under subsection D, the court may, and this is in the initial waiver, so I'm assuming some other judge did this for you, but if not, here it goes. You are being advised that of the charge that you have in front of you, the violation of probation for which you have a VOP that is pending, alleges that you violated condition number 3 about making a truthful report to your probation officer monthly, as that they required, and that you failed to report on 1/26/23, and that you on 1/27/23 a call was placed to you and contact was made. You said you were going to turn yourself in on the warrant. The potential penalty in this case is up to 5 years and or $5,000. And I will read this verbatim. Advising the defendant of the charge, the maximum possible prison sentence for the offense, any mandatory minimum required by law, and the risk involving self-representation. In addition to that, I will offer you the opportunity to consult with a lawyer that you can retain of your choosing. Currently you're in custody, so I'd also appoint the public defender's office if you wanted assistance. That's my understanding that you are not interested.
No assistance needed, Your Honor.
Okay. This is your choice. All right, so how are we proceeding with the violation of probation?
Your Honor, I don't respect the reason I'm here today, but I will not disrespect your court because of others' egregious actions towards me. This is our first time meeting, and I plan on it being our last. Before Mr. Breckenbridge left, I would have liked to address the whole panel. So that I had just a few questions for him to set precedent so that everyone's stance could be evident and clear and no misinterpretations. But I see Mr. Breckenbridge tucked tail and ran.
Well, we're making a recording and he's still here. He just was out of the camera view.
Great, great. Mr. Breckenbridge, can you please state your full name and title for the record?
Scott.
Mr. Lewis, this is not your hearing.
I can't address the panel.
There's no panel.
You have the probation officer, you have the court fines and fee officer, and you have the assistant.
And everyone put their appearances on the record. So we're going to move it along.
No problem. I can get right to it. That is fine.
All right.
The law is my protection, and I shall find remedy in it. Before we begin this process, I would like to address the court. In addressing the court, I would like to fully read and completely express all information today without interruption. I have 2 questions for the court. First question is, are all laws commercial? Second question.
Mr. Lewis.
Yes, ma'am.
We have a violation of probation in front of you. I understand that you have been arraigned on the violation of probation. And because you are decided that you want to act as your own counsel, I will hold you to the same standards as I would any other defense counsel in this same procedure and within this same case. So as to the violation of probation, you can accept responsibility by pleading guilty to the violation or no contest. You can set this matter for a hearing in which we go forward, but this is not your hearing to run. Do you understand?
Yes, ma'am. I just wanted to address the court and put on record some very variable value information. And by
asking me questions is not putting information that you have on the record.
Yes, ma'am. I won't ask any more questions. Can I finish my statement? I have no more questions.
My question for you is, how are we proceeding with the hearing today? Are we proceeding with an acceptance, or are we proceeding that we need to set this matter for hearing?
Ma'am, this is not even a hearing that we should be having. If I could finish my statement, you could see that unless the AG has certain information, this is totally in violation and I'm not able to express myself. Like I said, I have no more questions. I just would like to read the information I have, and then they can go which direction they want to after the information has been expressed, ma'am.
Okay, tell me if you feel like the petition for your violation of probation is wanton in some regard.
It is not wanted at all, Your Honor. I shouldn't be.
It's not wanton?
I shouldn't be.
So you believe that it's accurate?
No, I believe it's inert. I believe me being on probation is inert.
Okay. Quickly, Mr. Taft Lewis.
I can finish. Thank you. I am the de jure. I am not an imbecile in law. I do not surrender my inalienable rights for any civil liberties. I am a five-fifths realized being, and not because you're trying to enforce a contract/agreement by forcing me or compelling me to be a surety for.
Mr. Lewis, are you telling me that you're a sovereign citizen and you do not believe that the orders of the court apply to you?
No, ma'am, I'm not sovereign at all. I'm just speaking, I'm just expressing why.
That's what you just said.
I said I'm a five-fifths realized being, ma'am.
Okay.
That's
So
not.
these are, I need you, if you can't answer my question, we're going to adjourn this until you can get a hearing, and I'm going to appoint standby counsel of the public defender.
I don't want
Thank you.
counsel, ma'am. I just want to finish.
I understand that. So what I want you to do, and you don't have to have Mr. Gaddy right next to you during your event, but your hearing for next week. But what I want you to do is talk to him about your available option, because what's very clear to me is that you're not listening to the questions that are being posed to the court. Right? I say, are we having a hearing or are you accepting responsibility? I need an answer to that before we can go forward. You making a statement isn't evidence. That's not evidence, Mr. Lewis. And because you want to represent yourself, you're going to be held to the same standard as if you were a defense attorney appearing in front of this court. You can change your mind about that and have Mr. Gaddy represent you.
No, I don't want any.
But in the meantime, I'd like for you to talk to him in the next week so that you guys can discuss what the proper way is to go about dealing with the court. Because as of right now, you're not following the proper criminal procedure. You don't get to just make statements. There's an order to things. So you can find that out for Mr. Gaddy. This case is adjourned until next week. We'll see you back on the 6th. Or exactly, Ms. Armstrong, does that give you enough time, or do you need to put it out 2 weeks?
Be released.
Oh, sorry, Mr. Attorney General, does that give you enough time to do a writ, or do you need more time than that?
Judge, our office will request 2 weeks, just to ensure we have time.
We'll put it out 2 weeks.
Am I being remanded to jail, ma'am, or am I free to be released and come back in? Because I came in on my own accords, ma'am. I have no problem with coming back. Whatever day.
Like to make a bond motion, I'll hear that.
Yes, I would.
First, I'll put the recommendation from probation on the record.
Thank you.
The recommendation is for Mr. Lewis to serve 4 days in jail with 4 days credit. And to report to Agent Priest, to report to probation on March 2nd in the office. Your Honor, I'd also like to make note that I have a note here that indicates. Your Honor, may we approach?
Yeah. I'm sorry, ladies and gentlemen, for those of you, we need to have a private conversation because we have Mr. Attorney General is not here in person. We have to clear the courtroom. That prosecutors. Okay, Mr. Taft Lewis, got additional information. You know, if you wanted to see me, there's a different way to do that. If you have a motion, or part of that is by working with an attorney who knows how to navigate the procedures of the court. Again, your choice not to use an attorney. I still have the standby counsel for the public defender should you choose to avail yourself of their decades of legal knowledge that might help you navigate this process.
Ma'am, I thought this was the hearing. I didn't know it.
Pardon?
I thought this was the hearing because last week I could not speak also because he said it was your case and I would be able to have my turn to speak when I was in front of you. Now I'm in front of you and you're telling me this isn't the hearing also. So I didn't know how you guys were going to proceed. I just want to be heard on what information I have. Like I said before, I asked for this warrant so that I could get in front of you so that I could say this information to see which way.
And Mr. Taft Lewis, that's exactly what I'm saying, is that you had used the assistance of the public defender's office or your attorney who assisted you at the time of your case, you wouldn't have had to violate your probation to get in front of this court. I don't believe that you are a flight risk. I think you've just made poor decisions. So I am going to release you, but you're to respond here in person, which is March 6th.
No problem.
On Monday at 1:30 and that is the date and time set for your hearing.
Yes, ma'am.
At that time, I would expect you to follow the proper procedure that any other criminal defense attorney would be held to the same standard. You
Your
still
Honor.
have the public defender at your disposal if you choose to consult with them.
No problem.
Would you also order him to report in person to probation office on?
You'll have to report to probation tomorrow, I'm sorry, March 2nd?
Yes.
You'll report to probation on March 2nd to meet with your agent.
Which agent is that? Is that Agent Moses, Agent Miller, or Agent Priest?
Agent Priest.
No problem.
Your Honor, if I could ask Mr. Lewis to contact my office and give us the, address and phone number.
Did you hear that, Mr. Lewis? The public
Yes, I did.
defender is availing themselves to you.
I have no comment on that, but yes, I did hear him, ma'am.
I'm releasing you on PR.
Much appreciated, ma'am.
Okay, we
Is
will
that on
see you
all-
back
is
here.
that on all warrants? I had 3 warrants, one from the court fees and fines, I had one from FOC, and one from the violation of probation. Is that all warrants? I'll be released on PR?
Yes, and yes.
Much appreciated, ma'am. I will see you March 6th at 9
See you
a.m.
then. It's 1:30 p.m.
March
1:30.
6th.
You there at
March
1:30?
6th.
Yes, March 6th. I'll
Okay.
be there.
This case highlights a common pattern in sovereign citizen-related courtroom interactions, where defendants attempt to reject jurisdiction by relying on non-recognized legal theories, such as commercial law or personal sovereignty interpretations. However, these arguments have no legal standing in any recognized court system. The judge's role in this hearing is to maintain procedural order and ensure the case proceeds according to established law. When the defendant repeatedly interrupts with irrelevant legal claims, the court must redirect the discussion back to legally relevant issues, such as probation conditions and compliance. A key legal principle demonstrated here is that jurisdiction is determined by law and court authority, not by personal belief or refusal to recognize the court. Even self-represented defendants are fully bound by procedural rules and evidentiary standards. This case is a strong example of why sovereign citizen arguments consistently fail in court. They do not engage with actual legal statutes or procedures. Instead, courts rely on codified law, precedent, and due process. The takeaway is clear. Courtroom outcomes are decided by law and evidence, not ideology or internet-based legal theories.